Now, before we look at the judge's decision, let's just quickly compare Article 4.3 of the Australia-Thailand Treaty on the left to the OECD Model Convention as it was between 2009 and 2014 as represented in the judgment. So 4.3 in the Australia Thailand Treaty says, whereby reason of preceding provisions, an individual is a resident of both contracting states, the status of the person shall be determined in accordance with the following rules. The person shall be deemed to be a resident solely of the contracting state in which a permanent home is available to the person. And that coincides with paragraph A here, right? Where by reason of the provision of paragraph 1, an individual is a resident of both contracting states, then his status shall be determined as follows. He shall be deemed to be a resident only of the state in which he has a permanent home available to him. And then you kind of have to stop there, because paragraph B of the Australia-Thailand Treaty then goes on and says, you know, if he's got a permanent home in both states or in neither of them, the person shall be deemed to be a resident solely of a contracting state in which the person has an habitual abode. And then paragraph B of the OECD Model Convention also says he shall be deemed to be a resident only of the state in which he has an habitual abode. So that matches, but the conditions do not match, because in letter C of paragraph 3 of the Australia-Thailand Treaty, it says the person, you know, if it's habitual abode in both or neither of the states, then the person shall be deemed to be a resident solely of the contracting state with which the person's personal and economic relations are closer. And that is actually found in the OECD model as part of paragraph A. So there's two tests in paragraph A. A, do you have a permanent home? If you don't have a permanent home, he shall be deemed to be a resident only of the state with which his personal and economic relations are closer. In other words, his center of vital interest. And then in OECD, you go to habitual abode, as we then talked about, and when we talk about paragraph C in the OECD, talks about being a national. And for Australia, a national you don't find in paragraph 3, but you find that in paragraph 4. It says, for the purpose of the last preceding paragraph, an individual's citizenship or nationality of a contracting state shall be a factor in determining the degree of the person's personal and economic relations with that contracting state. So it only belongs to paragraph C, 3C. 4 relates to 3C. And in the OECD, of course, it's the fourth test, or the fifth test, and there are 2 in A, where you say if he has an habitual abode in both or neither states, then he shall be a resident only of the state of which he is a national. Sorry, that's the fourth test, because the fifth is mutual agreement. So the wording of the OECD Model Convention and the Australian treaties are similar, but the order in which the tests are made are different. And this is important because we're now going to look at what the court said about the application of the Australian part of Article 4.3. So let us see how the courts interpreted Article 4.3. And we start with the federal court, because they dealt with the first criteria about whether there was a permanent home. Right? And the commissioner's first submission was that taxing entitlement was resolved by Article 4.3a. First test, because only in Australia was there a permanent home available to Mr. Pike that was said to be a family home, right? And the judge first dismisses that family home and permanent home is one and the same. He's like, you know what, you cannot say the family home means permanent home. And then he goes on to consider, he says, the ordinary meaning of permanent is indefinitely continuing, lasting, or enduring. No different understanding is evident in the OECD commentary. And what he does before this is he goes through Australian case law on how to interpret treaties. And it's the usual obvious stuff. And it's the natural meaning of the words. You need to look at the text, you need to look at the context, etc., etc. And then you can also pay attention to the OECD commentaries. He does not, in this stage, refer to the Vienna Convention, but that will happen in the next court. So I'm leaving treaty interpretation out here for now, but he does look at the ordinary meaning of the word permanent. And then the question is, because they had rented homes in Australia and rented homes in Thailand, is this permanent, yes or no? And then he says, the accommodation occupied by Mr. Pike in Thailand and Australia between 2009 and 2014 was in each country his home and regarded by him as his home, a position which had prevailed there before 2009 as well, right? But the assessments only go from 2009, I guess, because they couldn't go back further. It was rented accommodation, but in neither case was the accommodation merely transient, right? Because it was a home where you could live. And then the judge go on to say, I do not consider that there be an inflexible rule of construction that a permanent home can never be a rented one. And it's an interesting comment. I think it says something about the percentage of home ownership in Australia, because I mean, living in Europe, I think a lot of people live in rented homes and see that as permanent, right? But in any case, in Australia, he made this point. And then he says, Mr. Pike and Mrs. Thornycroft contemplated the erection of a residence on Brookwater land, which would have constituted a permanent home, and that was the Gulf Estate. But the problem was they weren't allowed to build any houses there. So then they sold the land in 2013. And then he goes on to say, I consider, okay, so it says the only home in which they owned was the one in Narara, but they quit that in 2005 and never returned to it and sold it in 2010. This is the judge, says, I consider the better view is that neither Australia nor in Thailand did Mr. Pike have, in terms of Article 4.3a, a permanent home available to him, because these were rented accommodations. In each instance, for reasons already given, the flexibility of a relatively short-term residential tenancy evidently suited him, and in Australia, Miss Thornycroft too. The type of accommodation does not strike me as a permanent home. But even if I am wrong as to this, I would consider that there is no material difference between rented homes in Thailand and Australia, such that one could be characterized as a permanent and the other one not. So the tiebreaker first test, they either had permanent homes in both states, he had, because it's only his tax that we're talking about, or he had permanent homes in neither of the states because they were rented and they were short-termed. I think it's an interesting view. I never really thought that much about the word permanent in Article 4.3. I would say rented property can be permanent. To me, permanent would be more an issue of intention. I mean, you can buy houses and you can buy and sell a new house every 5 or 10 years, and I mean that would not be permanent either. It's all about the intention. But let's move on to the next criterion. Next, we need to look at habitual abode, whether Mr. Pike had his habitual abode in Thailand or in Australia or in both. And the primary judge said, as Article 4.3, letter A is inapplicable, so in other words, permanent home, one cascades to 4.3b. I like the word cascade. In each country, Mr. Pike had a habitual abode. Once again, though, there is nothing in my view to choose between Thailand and Australia. Mr. Pike's life routine had two aspects. One was that as, when, and for as long as necessary, and always for more than half a year, he worked in or from Thailand and occupied their premises which he had made his home. The other was that as, when, and for as long as possible, he lived with his family in Australia. I really like the writing of this judge. It is almost literature that one reads. But so the primary judge said there's an habitual abode in both states. And then he concludes, he says, as it happens, this approach, saying that there's an habitual abode in both states, accords with the understanding evident in the OECD commentary. And then he quotes I think the 77 or the 2007 version of the commentaries, and says, the application of the criterion requires the determinant of whether the individual lived habitually in the sense of being customarily or usually present in one of the two states, but not in the other during a given period. The test will not be satisfied by purely determining in which of the two countries the individual has spent more days during that period. Okay, so and this is I haven't thought about this before, but it's interesting to me saying, you know, habitual abode is not simply a matter of comparing the days. It again is, as we said earlier, one needs, with regard to interpreting impermanent, one needs to look at intention, right? So the judge goes on to quote the OECD and says habitual abode is a notion that refers to the frequency, duration, and regularity of stays that are part of the settled routine of an individual's life and are therefore more than transient. It is possible for an individual to have an habitual abode in both states, which would be the case if the individual was customarily or usually present in each state during the relevant period, regardless of the fact that he has spent more days in one state than in the other. So the judge was very clear here, but Mr. Pike disagreed, and the federal court, these were both cases by the Federal Court of Australia, but the first one was with one judge. The second, the appeal, was with 3 judges, and so the 3 judges right here. Mr. Pike contended that the primary judge erred in holding that he had an habitual abode in both countries when the period of time that he spent in Thailand was considerably more than the period of time that he has spent in Australia. So Mr. Pike's lawyers at least say you got to count the days, in spite of the fact that the judge quoted the OECD saying very clearly that you don't have to, right? And then they quote actually some text from the OECD, which they interpret as meaning that you must count the days, and the judge says that's not true. They quote a glossary of tax terms which explain that something about number of days, but the court just says, you know what, the glossary of tax terms is not part of the commentary and therefore doesn't need to be used for interpretation, which I find surprising, but that's fine. I think the language in the commentary is quite clear. And then they go on and they say the principles for construing a provision of a double tax agreement is well established, and we talked a little bit about this before, about you looking at the ordinary meaning of the words and all that stuff. And then it says the principles are contained in Article 31(1) and 32 of the Vienna Convention on Law of Treaties, require treaties to be interpreted in good faith and in accordance with the ordinary meaning of the given to the terms of the treaty in their context and in the light of its object and purpose. It is well established that the OECD commentary to the Model Tax Convention is a legitimate aid to construction. And I'm very happy that the Australian court says, but of course you use the commentary to interpret the treaty. As I've said in other videos, I do not agree with the academic view that you cannot use the commentary because it's only secondary means of interpretation. No, someone saying that doesn't understand how treaties are negotiated. So this is what the judge says, and then he comes to I come to article paragraph 19 of the 2017 commentary, which says a little bit the same as what the primary judge said in paragraph 98, but I just want to reiterate it. Right, it says The application of the criterion provided in subparagraph B, which is habitual abode, requires the determination of whether the individual lived habitually in the sense of being customarily or usually present in one of the two states but not in the other during a given period. And here it comes again. So Mr. Pike is wrong in his argument, because it says the test will not be satisfied by simply determining in which of the two contracting states the individual has spent more days during that period. And then it differs from what the primary judge has quoted, but I think this is because it's a 17 commentary. It says the phrase séjourne de façon habituelle. I'm not speaking French, so this is probably terrible pronunciation, which is used in the French version of subparagraph B, provides a useful insight as to the meaning of habitual abode, being a notion that refers to the frequency, duration, and regularity of stays that are part of the settled routine of an individual's life and are therefore more than transient. And the commentary goes on to explain, you know, that you really need to look at the broader context, and sometimes you also have to look at more of a period than just the period in which there was dual residence. And the court goes wrong here, because the federal court, the three judges, quotes the commentary, but they quote the wrong part of the commentary, right? They say, critically, it did not provide that a person's habitual abode is the place in which the person spends most of his time. Totally agree. See paragraph 19. Then they quote paragraph 19 from the 77 version, which is now, I believe, 19.1. And that says, in stipulating that in the two countries which it contemplates, preference is given to the contracting state where the individual has an habitual abode, subparagraph B does not specify over what length of time the comparison must be made. This is a different sentence, right? Subparagraph B does not specify over what length of time the comparison must be made. The comparison must cover a sufficient length of time for it to be possible to determine whether the resident in each of the two states is habitual, and to determine also the intervals at which the stays take place. And then an example follows, and what is very clear from the example and from the text here is what they're saying is you cannot only look at the period during which there was dual residence. Sometimes you must look at more than that period, right? And the example that they give, they say, imagine somebody habitually lives in one country for many years, and then he takes their employment for, I think, 190 days in another country, and he stays in that country while working there. But when he's done, he goes back to where he habitually lived. Then you can't just say that because he habitually lived quote unquote in the country where he worked for 190 days that he also had an habitual abode there. No, he had an habitual abode in country one, but not in the 190-day country, because that's not habitual, right? Not in the sense that paragraph 19 of the French text is explained here above. So the court quoted the wrong paragraph, but for the rest, the result of their argument is accurate, and they conclude and say, we agree with and adopt the reasons of the primary judge, which I've given you on the left-hand side of the slide, for concluding that during the relevant years, Mr. Pike had an habitual abode in both countries because he was there habitually. He worked in one state and he had family in the other state, and because you don't simply count the number of days. So then we need to move on to the next criteria to test where he was a resident.